All right, I'm gonna grab the kitty.
So a couple surprises that she doesn't know about. She doesn't know about cupcakes, which she is gonna love, and then she has no idea about the cat that I bought her. Hi, hello. One cat for me is good enough, but Amy really wanted a second cat. And so there's a certain type of cat Amy's been wanting. She really wanted that Savannah cat, and so
Hey everyone, it's Katie from Without a Crystal Ball. Welcome back to my channel. It's Tuesday, August 23rd. I hope you're having a wonderful day. All right, legal cases. Aren't they fun? Yes, I've had my share. I actually had a case dismissed last week. Yes. I'm working on the other ones going away too. But right now, we're going to talk about Amy Duggar and her husband Dylan, who are in their own legal hot water. And I just want to put this out there. Just because someone is sued doesn't mean that they are guilty of anything. Just because someone is sued doesn't mean they will go to trial. And just because someone is sued doesn't mean they've done anything wrong. Sometimes people sue for the sake of suing, and so that's why they have to go through this process. So we are not saying that she's done anything wrong by discussing this. We just want to give you an update on what's going on. So Amy Duggar King was running a shop called 3130. And if you guys remember, I actually used to buy from there a lot. I loved her clothes. She had really soft sweaters and really cute shirts. And I actually haven't had a boutique buy since then. I didn't buy any new clothes this summer. I've been wearing t-shirts. I've been in a very t-shirt vibey mood. But she had a shop that was online, and she had a storefront that was in Springdale. And she initially had a storefront that had like that big space, and it was actually not very far from her husband's restaurant, Wellington's. And when she was there, if you remember, she had Jill Duggar would go in and they would do some modeling, and she would buy clothes and stuff. I don't remember if you recall this, but it was like last year some point she went live and was talking about her landlord and how her landlord had thrown a bunch of boxes in her like store. And she was talking about how she would have to move, and she was going to need to move. And then they did move. So remember how she closed that shop down, and then she moved over to another place on the other side of town, and it was a smaller shop, but she said it was a great location. And then this spring, if you remember, she suddenly and abruptly closed the shop down and then like got sued. And she promised that she would be going online and reopening the store. So far, 3130 has not rebranded or reopened as an online shop, and she had said in May of 2022 that they were going to be bringing the store up online as an online only boutique. Right now 3130 you can't buy any clothes from her right now, and it could be because of this lawsuit. I don't know, it could be a whole host of other things too. So she's set to go to trial now, and that trial is scheduled for January 24th of 2022. So the lawsuit was actually filed in the beginning of May, and she, in the beginning of May, signed a lease agreement for 5 years. It was on October 8th of 2018, and the lease agreement was for $3,300 a month. They actually amended the agreement because they expanded the space. So basically what they did was they were renting one room, and they combined 2 units into one to make the space big enough for her store. And when they did that, she signed that in June of 2019. And incidentally, that was one of the last things that Mary Duggar actually signed. She was the notary that signed this amended lease agreement, and that lease agreement was for $66 a month. That's a lot of rent. And that's what she was going to be spending per month at this space. And that was for until May 31st of 2024. Okay. So the complaint said that 3130 occupied the present premise until August of 2021, at which time it vacated the premise, which constitutes default of the lease, an amendment, and breach of contract. It said that the 3130 failed to make the required monthly payments to the plaintiffs as required by the lease and amendment after June of 2021. So they stopped paying in June of 2021. She moves out in August 2021, according to the complaint. And they're requesting unpaid rent from June of 2021, plus court costs, interest, and attorney's fees. So she owes rent for June, July, and August, I guess. But she might have default on the lease agreement, which was through the 2024. So it's unclear to me like how much they want for her lease, like how much money they're seeking. They requested unpaid rent from June 2021, court costs, interest, and attorney's fees. And they responded by admitting that they vacated in August and insisted that the landlord was the only one who committed a prior material breach. They said to the extent that there was not prior material breach, defendants detrimentally relied on plaintiff's representation that they would not be future damages sought if the defendants paid outstanding rental amount, which plaintiff was to provide and did not. So in their response, their argument was that they had come to an agreement that they would vacate and that they wouldn't sue them if they would pay their back rent, and then they would just move forward. And they're saying that that was breached by them. So they also brought up some issues with an allowance for the amount of $31,000 for contractors to improve the space. And they said that any cost agreed over would be paid by Amy and Dylan. And they said that they hired a general contractor, the landlord did, to perform the renovations. And they said this is what their counterclaim says, is the landlord then deducted those charges from 3130's LLC's tenants improvement allowance and charged counterclaimants for what was represented to be all costs in excess of the allowance. And they were charged $66,000, including late fees. But they said the counterclaimants did not receive any supporting invoices at the time of the charges. And so they said upon information and belief, the landlord charged counterclaimants in excess of the amounts actually charged by the contractor or contractors in violation of the lease agreement. So upon information and belief means that right now it's just an assumption that this is what happened. They maybe don't know for sure that this is what happened. And then it says landlord also charged counterclaimants for work performed at units other than suites B and C that benefited the whole unit. And they said that they also they were required to pay for inadequate trash services as part of the utilities for the premises, but because trash service is under definition of common area, the landlord is contractually required to maintain it. And so they had a lot of boxes and didn't have enough space. They also said that on May 27th of 2021, the defendants were shocked to discover that the leased space had been broken into and trash had been thrown away. Even more shocking, upon review of the security camera footage, they discovered that the owner of the Hillcrest Holdings was the person that, without notice or warning, broke into 3130 clothing. And on the day in question, the owner, in apparent fit of rage, unlawfully broke into 3130 clothing and trashed the store. He can even be seen throwing garbage such as cardboard boxes and other rubbish throughout the store with little regard for the damage and the mess that he left. And it says, as a direct and proximate result of the landlord's breaches of the party's lease and deprivation of the peace and quiet enjoyment of the premises and the break-in, they were forced to relocate. So they said that everything was fine until he broke into their unit, which is what she actually said online, and threw trash all over the place. They said that they lost a lot of revenue having to relocate, and they demanded a jury trial. The landlord actually responded by denying everything. He said he returned several boxes the defendants had dumped on the property to the inside of their premise, and he requested that that be dismissed. So, yikes. Landlord disputes are always tricky. And I'm honestly, in this case, don't know if if Amy and Dylan have footage that he's doing what they claim and he's throwing trash into there and breaking into the premise when they're not supposed to be there, she might have grounds for her counterclaims, it seems odd that they filed this so many months later. So they vacated in August of 2021 and they didn't file this until May of 2022. It seems like a very long time for them to go without trying to resolve this privately. And that was even part of the counterclaims, was that they believed that if they would pay him the amount due, that he wouldn't be filing a lawsuit. And then 9 months later decides to file the lawsuit. So it is it's odd timing. And I don't know what prompted that. And it's weird too, because this is the same place that Dylan's business is for his restaurant. So Dylan's landlord is suing him for the clothing shop, but is still the landlord for the Wellington's restaurant that they own. He's a joint owner of Wellington's, so he has partners for that. But could you imagine how uncomfortable that would be for being Dylan? Like, you literally have your restaurant, and his restaurant apparently does pretty well. He's got 2 partners that have done restaurants in the past. And so that's independent of Amy, and that's been pretty successful for them. And then your landlord is suing you for another business that you had to move out of. It's kind of a weird twist of events here. I don't know how this is going to go. I really hope that Amy and Dylan are able to resolve this. You know, the non-payment issue doesn't seem to be really consistent with Amy in terms of, like, there's not another landlord suing her for non-payment. Dylan's company isn't being sued for non-payment. So I'm guessing for Amy, she felt violated when he broke in, throws the stuff on the floor. And I remember that Instagram live, she was really upset when that happened. I remember her going live about it. So can you really blame her for wanting to leave? And then does it seem petty for him to, like, file this 9 months later? And is he really trying to recruit just June? And does that really worth of, like, is that worth going to this? Or is he trying to recoup all 5 years? I mean, that's obscene. And isn't there, like, a clause for them to break a contract if something like this were to happen? If you are a lawyer that deals with legal real estate stuff, let me know what your thoughts are in the comments. And whose, like, side are you on this? I'm frankly actually on Amy's side on this, because I flat out remember when this happened, and I remember how upset she was and how devastated she was and how much she didn't want to have to move her shop, but she felt unsafe. So when it comes to this lawsuit, y'all, I'm Team Amy. What are your thoughts? Tell me in the comments below. Bye, guys.